All right, everybody, welcome to the next in our series of Why Community Matters with OmniSparks and Chicago Blockchain Project. This one in the series, we're going to be talking about legal issues with managing communities. Our guests today are Chris Williams and Elaine Wyder-Harshman from Convex Legal here in Chicago. Before we begin, let's talk a little bit about our sponsors here. So OmniSparks is a collaborative platform for communities to more efficiently manage their communities, and Chicago Blockchain Project is a community in Chicago that is building Chicago to be a blockchain capital world. We want to remind you to join us for the Voice of Blockchain, our big conference here in Chicago on September 30th and October 1st. That's voiceofblockchain.com. And next, we're going to go ahead and say hello to Chris and Elaine.
Hey, hello. How's it going?
Hello. Hi. Thank you, Joe.
All right. You guys look good down there in the corner of the screen, but we're going to go ahead and get to the presentation here for everybody. So feel free to jump into the chat room where I disrupted Joe. We'll be in the chat room talking to you guys. And Chris and Elaine are going to get onto the presentation. So I'm going to go ahead. We're going to take our cameras off here and get into the presentation.
What we're focused on here today is we're going to talk about the community management side of things, as well as at the end we're going to tap into the open source code and questions that were brought up to us beforehand. So to start out, we're just looking at the platforms, right? So what the difference between, say, your more traditional advertising versus the new social media platforms. And then we try to break those down even further. So there are blogs, and blogs would be Blogger, WordPress, Reddit, and even Twitter falls into that side, and you'll see why in a little bit. Then we do like the social professional networks. So that would be your Facebook, Instagram, LinkedIn. Then we move on to reviews, which are Yelp, Angie's List, Glassdoor. Bookmarking, that's your Pinboard or Dig. Media sharing is Vimeo, YouTube, all of those. And then you have your wikis and your final one would be virtual worlds. We're only going to tap into that very quickly, and you'll see the example and why we use it. But that's Second Life, World of Warcraft, things like that. So we'll start there. Good with. We can go to slides, or
No.
Oh, sorry. Okay, so when we're looking at these platforms, the first thing to consider is the rights that you are giving up based off the terms of service for the platforms. So even when it comes to your advertising, you might follow all of your rules, but there's also rules such as that are set by the different platforms. Our slide would show tons and tons of text that would make your eyes glaze over, and that's kind of the point, right? You want to go through and just know what your rights are. And that's really, with that part, it's just a matter of jumping to the right section. So going to advertising or the control find and look for advertising, and then look at what requirements are there. That way you don't have to read through everything, but you can find out what rights you're giving up. For example, some of the popular sites say that they're allowed to use your photos to advertise to your friends, or they use your photos to advertise the businesses they're working with. Not just photos, but any of the content you create. And that's user-generated content, which we'll call UGC through this whole thing. UGC is going to be important because that's what a lot of the social media relies on, right? A good portion of that is user-generated. And it's not, so that's where a lot of risks fall, just like in cybersecurity where the human is the big risk point. Well, the user-generated content is the big risk point for a lot of this marketing side of things. User-generated content, when it's on a social platform, the social platform might own it. They might be able to repurpose it, but it also matters for you yourself. For example, IP law, that's important. So whether you have a follower that created the artwork or they accidentally took someone else's artwork accidentally on purpose, you need to know ahead of time, because that can lead to different issues with the owner of the artwork actually causing you, or the content, whatever it is, causing you to take it down. They can cause a lot of trouble there for you. Some less obvious examples of this, though, are hashtags. So you might use a hashtag that mentions an event or a person or something that is trademarked, and you need to be careful with that. So you might be trying to build off the momentum of something else that's going on, in the world, but it could also lead to trademark issues there. So it's just something just one of those one-offs that you want to keep in the back of your mind. And then the last question is, who owns the user-generated content? This is something that you need to stipulate personally when your users are providing it to you. Whether that's through goodwill, they're just creating it because they're a fan of your company, or if you do like a contest or sweepstakes where user-generated content is required to be entered into that event. So you just want to, this is all under advertising law. You just kind of want to make sure that you're not violating any of that. And there's also, I mean, besides the fact that it's law, it's also good practice just that you want to keep your clients or your users happy. And just, you don't want to take something that you believe you can use, but then your user base said, no, that was still mine. And just creating a miscommunication there. Oh, great. Well, hang on one second here. We'll jump to the slides so you don't have to look at my face anymore. That's oh yeah. So then here's the next part. Don't spill the beans. Excuse me. So I'm just gonna back up for 1 second, one slide here. There's a little bit more on the user-generated content. For example, followers and contacts that are created through this. So when you start bringing in content managers, there are cases about who owns those followers. Now, people try to rely on the fact that that it used to be a trade secret, customer lists were a trade secret, but now because follower lists are public, that's not necessarily true. So then who owns these lists? The employee or the solicitor, we'll get into solicitors later, but just let's call them promoters of your company. They might actually own the list. It might not be the company itself. And there's at least one case out there that ruled that, for example, that LinkedIn connections aren't a trade secret. This again goes to the private versus public list side of things. One of the fun cases is Phone Dog versus Kravitz. So Phone Dog was a company and they wanted their employee to give them back the list. But the employee, Kravitz, was using his own personal list, got up to 17,000 followers, but then left. And when he left, he changed the name of his account, a Twitter account, changed the name of the Twitter account. So they didn't mention the company anymore. It was just him. The argument was that while he was talking about the company, the followers were actually following him. So the problem with, or the challenge with all of these social media conversations is that while there are a lot of cases that start, most of them settle before there's actually case law. So there's no real final judgment to lean on right now, or they either settle or they're just dismissed. Let's see. So then the other part of this user-generated content is also endorsements. Endorsements are a big one that people like to use, but you have to make sure that that everything that's being endorsed is true. The FTC will come after people for this side of things, and we'll get into some triggering events for FTC investigations later. FCC, they gave out guidance, that you can find on their site, but we can really just bring it down to 2 points. Don't have false or statements that you cannot justify or prove, and then make sure you disclose all material connections to advertiser endorsers. So if you give a promoter something for their endorsement, that needs to be stated along with the endorsement. This is also going to fall into when we start talking about, say, airdrops or something along those lines. We can dig into, you'll see how this starts to overlap and lay on top of itself, so that you're not just dealing with the SEC. Unfortunately, you have a lot of regulators, as everyone knows. So best practices with endorsements are just to make all the disclosures you need to make about whether someone's being compensated. Don't provide proposed language. It's supposed to be the endorser, the promoter, so don't tell them what to say. And then any statements that are made, make sure that they're provable. Let's see. Sorry, I'm going to jump ahead a little bit here just because I want to keep on track with time. And I think I beat that into the ground. And now we're going to get into don't spill the beans. And this is about confidential information. So a lot of companies have either trade secrets or they have confidential proprietary information, maybe relationships that they're trying to build out that they don't want in the public yet. And I had some friends, I'm sure I'm not the only one, they go out, they have a little fun like Pink Panther here, and then they think, oh, I have this cool story to tell you. This company I'm working with is doing X, Y, and Z. So you can go back to the person that spilled the confidential information and go out and show that they violated their confidentiality agreement. But then once the news is out there, it's out. And that's it. Either from the human factor that everyone knows about it, or two, from your confidentiality agreements. All of a sudden, everyone else is tied up with that. They're loosened up because that's now public information. There is language in most confidentiality agreements that say that if it was accidentally spilled, you still have to hold it in. But just be aware that once someone lets this information out, you're not getting it back. So really, when it comes to relationships that are going to start up, anything that you want to keep secret, like a relationship or some new technology, only tell people on a need-to-know basis, and don't share with your PR, your marketing. You can prep them, get them ready, but make sure that they know that should not go out to the public in any way. So really control the communication level. So just some quick tips here. Just know what is your IP and what someone else's, so you don't use someone else's information. The one I really just want to jump on quickly is the NLRA. That's just Section 7. It allows employees to communicate with each other for bargaining, which it shouldn't matter for community engagement, but really there are just a couple of restrictions. There are a couple of times you're not allowed to restrict communication between employees, and that's something they just want to consider because they can count social media under this. But then be clear about who owns your work product. Be clear about your right to amend someone's comments or delete them if you think that they're off topic. And that can count by in your social, whether it's a company site on Facebook or your website, a blog. Just make sure that you know how your rights play out on that, and you set those rights most of the time, depending on who's speaking. So contests and sweepstakes, this is another section where it's just, it's exciting because you can get people really engaged in your company. You can get a following pretty quickly. I'm going to quickly define a contest as based on skill. So the outcome depends on the participants. It's in the participants' control. A sweepstakes is more based on chance. So the outcome is based on factors that are outside the participants' control. So now you could think about the lotto, and that'd be, there are three factors that typically fall into a lottery, but not, it's very state specific, I need to be clear. But lotto is consideration from the user, and we'll talk about what consideration is for a chance to win a prize. So for a chance, the chance portion, and then a prize is the outcome. And then finally, giveaways, those offer a value for engagement, for a specific action. So think of buy one, get one free. That counts as a giveaway. So back to the lottery, back to all these to talk about consideration. Consideration is something of value. And so when you talk about value, that's going to be pretty broadly based, but we can knock some things out. For example, monopoly money. Monopoly money only works in Monopoly. However, things start to get a little more gray when you start talking about online gaming. So again, we can go back to Second Life, World of Warcraft, that side of things, where you can have consideration, whether that's promoting the game or paying in some way. But you receive a online product, right? Now you can say, oh, look, it's locked into online. But now they're even questioning. Then we get into the second part of consideration being of value, right? And value it's harder to define. So if you have a secondary market within your online environment, that's when you start to lean towards these new products that you receive. If you can put them into the secondary market, all of a sudden you have you have true consideration, true value for that chance to win a prize. I mean, if you take that a step further for our crypto sector, then all of a sudden these tokens on secondary markets, it becomes very clear that there's value there. It's going to be very hard to argue otherwise. So just make sure that you're aware of that. And again, we can talk about all the different regulators, but just some big ones that you're going to have to consider when you're dealing with this is FTC, FCC, SEC, the IRS. I'll have a very quick, I promise it won't be too boring slide, and then state regulators. Here we are. So free isn't always free, right? Facebook and Google have proven that data is valuable. So this goes back to the consideration that we were just talking about. By providing contact information, that's considered value. And then by taking specific actions for them, whether that's promotion in some way, again, considered value. Then we go back to taxes, right? If the IRS was able to take down Al Capone with taxes, then shouldn't be too bad for them taking down companies. Really, just a quick note here is that anything over $600 worth of value should be reported. It doesn't need to be necessarily reported by you, but you need to make clear to whoever receives it that the value of the prize. You'll make sure that they fill out a prize validation form, and then you make sure that they know they are responsible for all taxes due. So just make sure you keep that in the back of your mind. Along with that, I just have some quick tips on sweepstakes, on contest prizes. There's that boilerplate language you have in there, the no purchase necessary, void where prohibited by law, and purchasing something doesn't increase your chance of winning. But make sure you also have information on the duration, the deadlines for getting things in, who's eligible for it. If you can include the odds of winning something, that's great. How ties are broken. If you don't know what to put in, err on the side of putting too much in. So that was there. So now we're talking about the solicitor side of things. Excuse me. So this is where we're going to start to get into the actual managers of the content. So solicitors are people that are bringing work to you, and they receive something in exchange. So you have to make sure, so you can create a relationship this way, even if it's not a physical paper contract or a digital contract signed, you can still create relationships through actions. So you need to control what your promoters are saying. Are they making promises or guarantees? Are they making false statements? You can't be hands-off, which you'll see in another slide. You can't be hands-off about it and say, well, they're not our employee, it's not our fault. Make sure they're not making misleading statements. Make sure they're not entering your company into contracts or selling. This all sounds like doom and gloom. I want to remind you that there are very positive reasons to have community managers. They control the conversation that are going. They keep the engagement alive. They keep people interested. They do send out information that's necessary about stuff that's coming up. So don't think that we're not trying to be depressing here, but we're just trying to make sure that you stay on track. These community managers, they need to be very clear about what they're saying to people, because that's where these FTC triggers can come into place. FTC can start investigating, and they stay quiet about it. They don't just come to you immediately as soon as they think that there's some interest or they have some interest in you. But these trigger points can be people that had a misunderstanding with you and they're angry. A news article that comes out about the company that might draw attention. Other regulators can send information to them. Your competitors might want to slow you down a notch. And so if they see something they find misleading or untruthful, they might send this over. And then nonprofits like the Better Business Bureau, they can send information. So all of this control of your community managers also leads back to the same part where we're talking about user-generated content. And that's where we look at user-generated content is also parallels with work product. So you have a couple options there. You can let whoever creates the information, they can own it, they can control it. But that doesn't mean you're not liable for misleading statements. It doesn't mean that you're not liable. So it's very good to own or to have some sort of guidelines. So I'll talk about best practices, but some sort of guidelines about what you want to do, about who's going to own the work product, whether it's you or they get to keep it. And then are you allowed to do offshoots of that work? Can you manipulate it in some way and still use it? That side. So some quick tips there are just that, just a set guidelines. So it's still exciting. Remember, it's exciting. You want people to be really energized, but you don't want to let out those company secrets. So just kind of create guidelines that let you maintain control, so that so your confidentiality doesn't get blown up, but that you also allow the freedom for whether they're employees or promoters, that they don't feel stifled, right? That they're able to keep talking to people. And I'm sorry, you guys, I'm sorry to ramble on this, but I just want to get through, and I feel like we're going to run out of time. So security side of things. So loose lip sync ships, right? If you're trying to do a raise for your company, you're going to be regulated in some way. You need to know what regulation you're trying to fall under. I think it's becoming more and more clear, more and more common to hear Reg D, the Reg D exemption for raising. That's a private raise. And then even within Reg D, though, there's 506B and C. So now you're splitting up into subsections. This is where, and I hate to sound self-promoting, but this is where you really do want to talk to an attorney, just because you're going to start to follow into nuances. If you're in a B, you can have non-accredited investors, a limited number, but you can have a couple, but then you're really not allowed to talk about the raise in public. If you have a C, you can only have accredited investors, but now you're allowed more freedom on how you promote the raise you're doing. So now all of this, did you want to jump in now? Okay, so all of this is, you can't be hands off, right? And that's what we're trying to get at here. Because what's happening now is you don't want certain whenever you're promoting the raise, you're going to need to have the appropriate disclosures. And that's where social media gets tricky. Social media is more a casual conversation. But now all of a sudden, if someone makes a forward-looking statement, that's the one that everyone hears. Past performance doesn't equal future results, and that sort of information. You don't want to have to add that to the end of every post you make. It feels very stifling. But you do need to make those disclosures. So now you can add, it's not ideal, but maybe you have a link to the disclaimers, right? And you maybe you pin that to the top of your social site. It's, again, this is where you need to start talking to someone that's done a raise, someone that knows what's going on, where they can tell you the legal implications, and then you can apply the business sense to this. For example, Twitter, with the limited number of characters, how are you going to make any statement about the raise and qualify and still get the disclaimers in? That's not going to happen. So you need to be very careful about what you do there. Going back to the idea of the securities as well, then we get into the airdrops and bounties. So you're starting to lay over a couple different situations here. And this isn't new. I want to back up and say that all these challenges, they're not new and just to blockchain. So when we're looking at it from the marketing standpoint, so everyone wants to feel like this is a new frontier, and it is on the technology side. It is on how things are being raised, but not on the promotion side. So the FTC knows how to handle this. Websites, there were old cases during the dot-com boom that also did something very similar to airdrops, where they were giving away free stock to recipients that did either disclose personal information and then they received shares, or they got bonuses for soliciting other investors or other people to give their information. And the SEC found that these techniques, issuers received a value by promoting these, they call them fledgling public markets, right? So they promoted these shares and how to get them. Even though the shares were considered, it looked like they were free, that public information, again, that we saw, or the private information that's shared, again, that we saw, Facebook knows it's valuable, Google knows it's valuable, the SEC knows it's valuable. So they consider that consideration for these shares. It also increased the traffic to their websites and then possibly some public projects. So all of that is similar to the airdrop, where you're giving away free tokens to get a user base to build the value of the company. So by building that value, you can equate that to the shares and the security that way. So I hope that helps people with the share side of things. Then just you need to be careful with the advertising disclosures, as we mentioned. Sorry, I'm going to start really trying to rip through this quickly.
Well,
I don't want to. I'm sure people don't want to hear me talking forever as well. So let's keep. Whoops, excuse me. So just if I can just jump on the disclosure thing for two more points that might be interesting to people. Again, that is not new necessarily. Is disclosure requirements for the Netflix CEO. At one point, he was actually accused of having false or additional accounts, personal accounts, and was promoting the good nature of Netflix, so upping their ratings on different rating sites. Now, the SEC did investigate, but in the end, it was more embarrassing than anything else. The SEC investigation was dropped when the CEO was saying, "Hey, look, I didn't actually disclose any private information." But more popular right now, or more on top of people's minds, would be Elon Musk and how he made those statements about creating, having enough private money or enough investor money to privatize Tesla, and shares went up 6%. The SEC jumped on that immediately, and that was a disclosure that needed to be controlled, and so the shareholders went after him as well. So thank you for listening to me. I'm going to jump over to Elaine now.
Hello. Hey. Can you see me?
No.
Probably not. Okay. So I just wanted to raise a couple more issues when we get into decentralized communities. Where there isn't an official entity that's creating a cryptocurrency, but you have a bunch of people working together on the code and communicating on Telegram or Reddit or wherever, and talking up this group project. You get some additional issues that can be kind of challenging legally, right? How do we? Oh, quick. Okay. Yes. First, you would think that if you're part of a decentralized community without a formal structure, that you wouldn't really have a company that could get into trouble with the SEC or state regulators, but not necessarily. The default relationship, if you have a core team of people who are controlling this project, controlling that repository of information and approving changes or not to code and to what is distributed and to what is marketed, then you actually can accidentally have a business entity. The default relationship is called a general partnership. In a general partnership, you are liable for things that the other partners do. So if someone makes a mistake and is promoting your tokens, which happen to be securities, without complying, everybody involved in a general partnership could theoretically be liable. The same is true. Some states have what is called an unincorporated association. So they'll treat you as if you were a corporation, even though you haven't gone through the formalities if you're acting like one. So you can accidentally form a legal entity that you were not aware of. Now, of course, there are enforcement questions. It's hard to track down. Where are these people? They could be all over the world. There was a recent case in Colorado where someone tried to sue the issuers of an ICO, and there was no personal jurisdiction over the people they were suing because you couldn't even say where they were, really. Maybe some of them were overseas, that kind of thing. So that's an interesting issue. But if you are all based in the United States here, certainly you can form an entity without needing to. There are also issues to consider about your product when you release it out into the world. A lot of the ideal is to work together to create this thing and then have smart contracts that run by themselves on the blockchain. Maybe they do transactions. Maybe they simulate futures products and other regulated products, do swaps, that kind of thing. What is your responsibility for that code once it's out there? Let's see, press a little harder. And also who owns this material, right? Taking a step back, when you have open source code, you may have a general license that allows everybody to use it, but when you build on top of that, when you take modules of open source code and continue to make what they call derivative works in copyright terms, very often, depending on the license, those new programs may be subject to the same licensing requirements as the original source code. It depends. You're going to have to check very carefully what kind of license you have, wherever you grab that material from, because it could limit the ability to exploit it commercially later, right? But that's generally not the ideal in these open source communities anyway, right? Where you have decentralized communities. So we get back to the other issue: is this pretty much just a group project, or can coders actually be liable? The law is still developing in this area. The CFTC, Commodity Futures Trading Commission, has suggested recently that they're going to start to look at whether people who are creating individual smart contracts are still responsible for some of the activity that goes on in those smart contracts, right? So if it was foreseeable that the use of the smart contract would be illegal in the United States, it's possible that coders could be held liable for those kinds of things, even though they've kind of created the code and set it free and said to everybody, do with it what you will. So there are also questions whether smart contract coders can be liable for errors that or security failures that creep in. And this is largely undecided still, the extent of liability. So this is an evolving area. It's just something to, if you're managing an open source community or a decentralized, or yes, there are managers even in decentralized communities sometimes. If you're part of that enterprise, these are some things to think about as well.
Well, thank you for listening to us go through this. We always have to put the fine print in there, but we hope you found this this informative. And if you have questions, know that this isn't legal advice. This is because your situation is going to be more nuanced, and especially with the rules that matter, or the rules that matter for your particular situation. But I hope through all this that we still don't scare you off in any way. The social media and marketing, it's very important. It gets the word out there, and we don't want you to stop from doing it. Just have a plan ahead of time. Sure.
Yeah, sure. Let's see us one more time. We all lean in there. Okay, Joe, come on in.
Yeah. All right.
Hi.
I want to thank everybody for coming out and be a part of this. We'll go ahead and cut up all these questions and get them onto the YouTube for everybody, so you can go back and reference anything that you thought was great material. And we look forward to seeing you in a couple weeks, where we have Danny and Meredith from the Hero team, which has 150,000 people in their wait list, and they just got up to 4,000 people in their beta product. They're scaling out the participation slowly so they don't overwhelm those servers, and also take a deliberate approach to how they manage their community, and making sure they have the resources, the support available to their community in a very quickly scaling project. So that should be a very interesting conversation. Elaine, Chris,
right.
Thank you very much.
Thank you very much for having us.
Absolutely, and that is it. Bye, everybody.